The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free.
Alrighty, everybody, welcome. So I thought I would come on and talk about the case with you guys. I think there's some misunderstandings, I think, of what's going on, or at least what I understand to be going on. So we're going to talk about that. But I saw your comment there, Chris. I agree. South Carolina seems to really get their cases taken care of pretty quickly before trial, or at least partially. What's going on in this case? As you know, yesterday we were all expecting opening statements. Didn't happen. And my understanding from what I've seen is the defendant's attorneys were trying to negotiate a plea. If you guys aren't aware of everything that's going on with this case, this is actually a multiple defendant case. So this gentleman is accused of killing the significant other of his mistress, I guess you'd say. And for the last 4 years, she's been out on home confinement. She was back. I think she was in jail. She spent a grand total of maybe 3-4 months. And he has been in jail since 2021 because he got his bond revoked. So he's been sitting in jail for 3 years. Now, what's happening right now, or what was happening yesterday, is his defense team was trying to negotiate with the prosecutors to allow him to plead to accessory after the fact and cooperate. Now, one thing to understand about the sentencing guidelines and the way sentences work in South Carolina, to my understanding from my research, and again, if I'm wrong about anything I tell you, I apologize. This is just for my own independent research. I believe what's happening right now, the reason why he's willing to plead to accessory after the fact, is because South Carolina is unique in the way they apply their good time standards. If the maximum sentence of what you're pleading to is 20 years or more, then you have to serve 85% of your sentence. So Jamie Komorowski, the reason why you saw the reaction that she gave is because she's got to do a minimum of 21 years. Because her maximum on the charge that she was sentenced on was 30 years. So when the judge gave her 25, she ensured she will spend 21 years in prison. Now, this gentleman, if he pleads to accessory after the fact, the maximum charge is 15 years, which means if you have a charge, if the sentence in South Carolina is less than 20 years, you only have to serve a third. If you have good behavior, participate, max out your programs, he would be able to be out in as little as 5 years. So if you look at the time he's already spent in jail, which is about 3 years, a little over 3 years, and you look at, he would have 2 years to go into the prison system, complete his programs. He would get credit for the time he's already served. He would get since he's been on good behavior. So, what he's looking at right now, or the reason why he's willing to plead guilty to the accessory, is because he could be out in as little as 2 years. So, as a result, his attorneys were trying to get a cooperation agreement that he would testify against against the lady that's involved in this, who he's no longer associated with because he's been in jail. Now, understand, she's out on bond right now. She's on house arrest. She has been since 2020, which I think is interesting because you have this gentleman who helped her. You have the person who did this allegedly, shot her husband. This guy helps her dispose of the body. And this lady's been running around, apparently going to bars, breaking home confinement repeatedly over the last 4 years. And the judge in the case continues to allow her to stay out on home confinement. She's been in violation 3 times from what I've seen. So kind of crazy, because it's like, why is she out? I mean, she plotted to kill the father of her children, and she's out living her life. Apparently she was able to go up to North Carolina and build a church. That's exactly right, Chris. It looks like, I mean, there was a judge who left the case, and then there's this new judge in the case now. He left the case like 6 months ago, and nobody knows why. But Dontell's attorneys asked him to leave. Now, she was supposed to be standing trial this week with him, but then once again, she got one of these continuances right now where the case has been continued indefinitely. So what I see in South Carolina continuously happening is the people who have money and means and the ability to hire attorneys, they hire these state legislators like Murdoch did, like the guy who lit his wife on fire. And then these state legislators have pool with judges and stuff. And then the first step they do is delay the case. They get them out on bond. And of course, obviously, like my dad used to say, if the case isn't going to trial, they're free. So, I mean, they're not completely free, but this lady's been roaming around, going to bars, going to private residences, just wantonly breaking her home confinement, and makes no difference to the court. Yes, it's indefinitely, Chris, because I guess they just don't have a date set in the future at this point. I'm sure what will happen is there'll be a status conference or whatnot, and another trial date will be set. But she's had like 6, 7 trial dates, and they continue to get continued. So, and again, if you recall, the gentleman that he was ultimately acquitted of all the charges last month, but he was trying, even on the date of his trial that he ended up acquitted on, he was trying to get a 6-month delay because he said there was still evidence that needed tested, et cetera. And the judge in that case put his foot down and said, enough's enough, we're going to trial. So it's interesting how it works here in South Carolina. So what I wanted to show you guys, just to get the update, Chris says it's not about the law in South Carolina. It's about, absolutely. Well, I mean, absolutely. J.P. Miller, yeah, the guy who, well, we don't know exactly what happened there with his wife, but it doesn't look good. But I mean, look at the Murdochs. I mean, they ran that county, that area for years because they were the solicitors, and they held all the power. And that's why I believe Murdoch, if he did this, at least the financial crimes, I think he thought he would never really be held accountable. And then if he did do, again, he's been convicted of it, but there is some potential doubt there about what happened. Although, he's been convicted and so far it stands. But I think if he did that, I think he believed that his relationship with the solicitor's office was going to keep him insulated from getting ever charged, and it was going to go away. Of course, that's not what happened. They threw that guy out of the case and brought in the SLED and started investigating. And of course, state attorney general's office took over the prosecution of the case, and he ended up ultimately indicted. And of course, he followed the same prescription. He got, Dick Harpootlian, who's again a legislator who came in. Now they went the different route. They believed that they forced a quick trial because they believed there was DNA evidence that wasn't able to get processed, and that was a strategic thing that didn't end up working in their favor because he was ultimately convicted. Although I think he really thought he was going to be found not guilty. Because of when the whole thing with the shirt blew up and the blood wasn't what it was and there were lies, they thought, let's rush this thing in before they get a chance to try to find anything else or do anything else. And they thought the speedy trial would be a strategic move that blew up in their face. But one can assess now once a verdict has come in whether or not that was a good idea or not. I mean, I think that with that case, I don't know that waiting longer would have helped, but maybe. I mean, maybe things could have developed a little bit more. Maybe they could have gotten some experts out there to figure out exactly how this thing went down. I'm inclined on the Murdaugh case to believe that that he might have had somebody come out and do it. I think he had help because some things don't necessarily line up with things. And my understanding is there's an interesting wrinkle to the Murdaugh case where somebody bought his house and they've taken that door and they've gotten experts to look at it. And the experts have come back and said that, no, it's impossible that he could have been the guy doing everything that they said. And allegedly that's being given to his appellate lawyers, and they're going to continue pursuing that. So I think there's some problems with that case. But I think, overwhelmingly the guy's a bad guy. So do I feel bad for him? No. But do I think that if there is somebody out there who did something to his family and they're still walking, that's not good either, because we need to have that person or persons. But I do believe he was involved in whatever it was, whether it was his own involvement in criminal activity that caused these people to come do something to his family, or he decided to off them. Although I really have a hard time with the state's theory of that case because it just made no sense that he would decide that the way he's going to remedy a civil action in a county that he was so arrogantly in charge of, that he goes, oh, I'm going to just go kill my family. So now everybody comes in and looks at my financial picture. That never made sense to me. That just sounded so stupid. And it was his civil lawyer. It was the civil people who were filing civil suits against him who concocted that with the prosecutors to make themselves look like heroes and try to help push their civil case. And it worked, but it still doesn't make it any less ridiculous when you look at it on its face. And obviously the jury bought it and said, yeah, they didn't like him. But I think there's a lot of issues that we're going to see the Murdaugh too, because the financial crimes, I don't think they should have come in, or at least not to the extent that they did. I think the state went well beyond what they should have done. They pushed that to the limit. And I think the prejudicial effect of that was terrible on the jury. And then on top of that, you've still got the jury issues with that's going to be considered by the higher court. I mean, there's a lot of stuff that I think is going to tell that we're going to possibly see that trial done again. Will it have a different outcome? I don't know. But rest assured, I'm sure his attorneys are working right now in preparation for that second opportunity, because I know guys like Dick Harpootlian, I can't remember the other guy that was his attorney, it gets in their crawl when they lose a case like that. Oh yeah, Chris, and that's the thing. That's what's interesting about it. He'll never walk out. He's got federal and state financial crime charges that will keep him in jail for the rest of his life. So the fact that he's maintaining his innocence is, on this is interesting to me, because I think it shows that it's something that it's like there does tend to be sometimes with criminals, they're willing to go to prison for things that they did, and they might try to go to trial and get away with it, but when they're accused of something so terrible, like what he did to his family, I just don't think he would have done that to his family. It doesn't make sense. Now, had he been a recipient of like $10 million, now I would be on board thinking, okay, that would make sense because this guy's all about money. But the fact that it did the opposite of what you would think you would want in that situation, where it brought attention that ultimately got him arrested for financial crimes, that has put him away for the rest of his life, doesn't make any sense. Like, he would know that the house of cards he's living on, there's nothing that's going to stop. Like, the idea that you're like, okay, well, I avoided this civil case. Listen, he would have more pull getting out of that civil case because of the pull he had around, that he could have avoided that and avoided that and avoided that. You don't gun down your family to avoid a court date. That's just ridiculous. That then the act of doing that invites now more scrutiny on you. This makes no sense. Anyways, sorry, I got off on a tangent on that case, but let's get to what I want to really look at here, and it's this here. So this is an article that just came out this morning, and it says, and this is telling us what is expected to happen this morning when court convenes. He's expected to enter a guilty plea to one charge, and it's going to be accessory after the fact, and it's expected that he will then stand trial for the rest of the charge. So he's expected to enter the plea on the accessory charge, but stand trial on the rest. And opening statements are still scheduled. And then there you see the lady that he conspired with. But I think, obviously, I have this gut feeling on this, that I think that the state and the defense, because, I mean, if he's willing to testify against her, that's going to really strengthen the state's case and position. And if all he did was help her after the fact, and the state's confident of that, it would make sense to make a deal with him. But I don't know. I think they're probably stuck on the idea that 15 years, he gets out in 5. The look of that is probably something the state's like, we don't like that. But we'll see what they come up with and see if this thing actually goes forward to trial. It's expected to be a lengthy trial. It'll be an interesting trial, I think. Now, especially that his defense now, by pleading guilty, it gives them the leeway to it gives them the leeway to argue. Says, Dontell, are you here with us? Who's that, Crystal? What is this now? Who is this? Who's that, Crystal? I don't know who that is. At Crystal Dontell, are you here with us? Is that somebody that's related to Mr. Dontell? I don't know. Maybe I'm missing. Let me go in and maybe I'm missing a comment. I don't know. Let's see. Oh, his sister that was chatting with us. Oh, okay. I didn't know we had a sister in here yesterday. Oh, wow. That's awesome. I did not realize that. I was over there. I need to go back, I guess, and review the chat. That's amazing that we had that in here, because I was over in the Ole Miss college student case. I think that one's going to be a really fun one to watch because it's a mystery. It's a good old fashioned mystery. I don't think it's much of a mystery, because I think the circumstantial evidence against this young man is going to ultimately get him, but we'll see. And again, another case where he's hired another state senator to represent him. So I don't know what it is with these southern states and their state senators and the lawyers that go to the state Senate and House of Representatives, and they I guess utilize their juice in the courtroom to get favor. But yeah, I think this is going to open up this if this case goes to does go to trial. I think it's going to be an interesting one because his defense now is going to be like, he's going to concede to some of what the state's coming in. So it's gonna totally throw off the state's strategy, because it's one thing, when you have accessory after the fact, it just kind of follows if you can prove that he did it. But now the defense comes in. I have a feeling this guy's going to testify. Now, this is what I don't understand. All the news media was saying this guy was going to testify on day one. So I don't understand that at all. I mean, and then they're talking about that the son is going to talk during the opening statement. So what South Carolina has going here, must have a different trial format, or something is different about this trial than I've ever seen. So that makes me intrigued as well to understand what the heck is happening here. Why are you having a victim talk during opening statements? I've never seen that. And two, what is the defendant testifying about on day one? I mean, unless he's testifying outside the presence of the jury about something, unless he's allocuting on the guilty plea. I was going to say, Chris, I mean, I'm very curious. I have not. I mean, I've seen a lot of South Carolina trials but I've never seen those things happen. But apparently, it's happening. So we're going to be watching. So it's going to be it's going to be a busy day, because we're going to be bouncing back and forth between Mississippi and South Carolina, right? And seeing what's going on over there, because that other case just absolutely blows your mind on what's going on over there with that case, because the defense is basically, and again, it's a valid argument. This is going to be a real tough one. And judging from the makeup of that jury, I think it's very interesting. You hear the judge talking about church and everything, and then you see all these issues. I really believe that the defense is going to try to hone in. This jury seems like they might not be as open-minded to deal with the issues of this case as, say, other juries in other states. And I almost feel like they're going to be leaning on the jury to say, like, disregard this victim, which I think would be horrible. Because if this guy did this to him, what they're saying, it can't stand. It cannot stand. How you doing, Deanie? Welcome. We were just talking about what's going to be happening here with the coroner case. We're talking about the Mississippi case. It's going to be a real interesting day. Now tomorrow is going to be even crazier, because we're going to be covering 3 cases again. So because Ferris gets sentenced tomorrow, so we're going to have the Ferris sentencing. We're going to have these 2 trials going, if they're going now, in the event that the coroner trial, if they fully work out a deal to resolve the trial, then we might only be doing 2 again. But we'll see. Because I do believe it's tomorrow, the 5th. Tomorrow is the 5th. So yes, that would be right. So that'll be interesting. Although really the Ferris sentencing is more of just watching and seeing, because I don't think she's going to. I don't think there's really much question on what her sentence will be. She's getting life. I mean, and even if she doesn't get life, she's getting life, because there's really not a sentence she's going to be given that won't result in her spending the rest of her life in prison. It'll just be interesting to see her back in prison garb here and see if Scott actually has the nerve to come to the sentencing hearing and speak. Can you imagine the potential guy who participated in this crime when you comes to your sentencing hearing? I mean, it's like something out of a movie. So that's the stuff we're waiting, or at least I'm waiting to see in the Ferris hearing tomorrow. But that's where we stand with that. So the coroner case was supposed to be beginning at 9:30. It's 9:44, keeping with form here throughout this case, which has been that they've been running late. So that tells me there's stuff still going on in the background. Like I said, I don't anticipate this case makes it through. I just don't. I think they are gonna work out a plea, because it's too good of an opportunity. Christine, yes, I was going over that. So sort of, kind of, what he did so far is his attorneys are working on trying to hammer out a deal. But what it sounds like he's going to do is plead out to the accessory after the fact and go forward on the other charges. And that's going to allow him to argue that he's innocent of the other charges and that all he did was help her after the fact. And one of the strategic reasons he's going to do that is because South Carolina, if the maximum sentence for a charge, and in South Carolina, the maximum sentence for that charge is 15 years. But if the maximum sentence is 20 years or less, then you only have to serve 1/3 of your sentence with good behavior factored in. That means you mind the rules, you have to take advantage of all the different programs, but that would mean he could be out in as little as 5 years. And given that he's already served 3, he'd be out in a little under 2 years potentially if he got into prison and cooperated and did all the programs, and he'd be out in the next 2 years. So for him, facing life, if he's able to work out a deal like that, or he works out a deal where maybe he pleads to something else, to one of the other charges as well, it gets him maybe a little extra time. As long as the maximum charge is less than 20 years, they'd still be able to get their headline 20, 25-year sentence, but he's only serving 1/3 of the sentence. So South Carolina has a little bit of a favorable sentencing law. You get 240 days a year, good time, if you have a sentence less than 20 years. I guess it's a way of like keeping the prison population down for less serious crimes. But if your sentence is over 20 years, you have to serve 85% of your sentence. So I think he's got a huge interest right now, and that's part of what's going on in the negotiations, is being able to give the judge the opportunity to stack the sentences, but give a 30-year sentence and he does 10. That's if they could stack the charges. But the important part is he can't plead to anything with 20 years or more of a max sentence. Then he's at 85%. So I think they're doing a tightrope walk. Certainly can't plead to any of the unaliving charges or anything like that, because all of those are going to carry for over 20 years. And so that's where we're at right now. I think that's where the delays are at, because I think they've got a co-defendant in this case, and I think the state is very interested in trying to get her locked down and get her convicted. And since this guy is willing to say she's the one that did this, he would be able to cooperate and pretty much deliver them a conviction, or at least give them a strong likelihood of a conviction. So I think that's where they're at right now, is saying, hey, how can we get your cooperation? Because if he goes to trial, beats the case, and then does the 15, which is really 5, they lose all leverage. They're not going to get him to testify. I mean, unless he just wants to hang her, but chances are he probably won't. So it's a very tight rope to walk upon right now for the prosecutors. You're trying to assess, what do you do here? You have an opportunity to get a cooperating witness, and he's been locked up now for 3 years. So this is part of the benefits of his situation. The other co-defendant, the lady, has been out on bond. Okay, she's been out on bond, flouting the terms of her bond. She's had multiple violations for being in bars and going to private residences, at least from what I understand. And she's just, been generally non-compliant. But the judges, for whatever reason, allow her to stay out, even though she's the one who allegedly pulled the trigger here. Now, I imagine her defense now is going to be that this guy did it all, and that maybe she helped. I don't know. But for her, she's been on home confinement. Now, do understand this, and this is a downside to her home confinement. She did get some consideration to go and build a church in North Carolina. But in South Carolina, if your home confinement does not allow you to leave, but for medical reasons or stuff or things like that, but you're basically in jail at your house, then you're going to get credit for that time you serve. So, she could essentially do the same thing and plead out to accessory after the fact, and then say, well, this guy did it. So I think the state's got to figure out, in their mind, did they do it together, or is this a situation where one might have been not guilty, one might have done it, and the other helped the other? But they've got to be prepared. Now, for her right now, she was supposed to go on trial with him this week, and her case has once again, for like the sixth time, been indefinitely continued. So she's not free, but on home confinement right now. And nobody knows when she's going to get tried. So very, very interesting maneuverings here in this case. So let me check my other case here. All right, so it looks like we are in session over there. So let's roll to live. And yeah, so we're going to go up on both over there and over here. It looks like that one's about to begin. So at least they're being prompt. That's supposed to begin at 10 o'clock. So whether you're over there or over here, you're going to see me in both. I can do that through AI software magic. So whether you're going to be watching that trial, if you want to switch over and transport over there. Right now, like I said, once again, this case here was supposed to start at 9:30. Nowhere to be found. Christine Fortunato, great question. We do not. I have not heard from him. I know he was in the process of getting his phone. Like I said, he has no phone or computer at this point. And he had to wait to get it out. Last I heard, he was waiting to get that out of the evidence locker. He was supposed to do that yesterday, but he was also considering, because he kind of realized, I think, that phone and that computer wasn't going to work. He was considering maybe not even doing that, foregoing that, and heading up to Miami. So there we are. So guys, if you're, I'm just popped up here. If you're watching this over here, I'm talking on both streams. So you guys are going to pick up with the conversation. If you're on in the conversation we're already at right now, so it says, well, look what they did to use yesterday. Laugh out loud. What did they do to me yesterday? I don't know what they did to me yesterday. But yeah, Christine. So right now, no update on Ty. But as soon as he contacts or reaches out or he gets back online, I think Lauren was working with him to try to get his old phone and computer to him, from my understanding last time I spoke with them. That's what was happening there. So we'll see what happens with that. But as of right now, it looks like we're going to be live in the Mississippi case. So once that goes live, I'm going to quiet down and I'll be over watching that, and then I'll keep my eye on this case. To us. Okay, I was about to say, I was like, did they do something to me? Oh yeah, I know. Yesterday was, like I said, I mean, that's why I said I think this case is just, to me, I think it's a strong possibility that we're going to get a plea today. I think they're going to take care of the case. I think that's what they're working towards. I mean, if the prosecution doesn't do that, you got a guy who's already in jail and he's bringing a story to them. So I think what they're trying to do right now is they understand the risks that taking this to trial for him and getting this wrong. And if he's found not guilty, they lose all leverage. So now it's like, hey, we're willing to, again, imagine this: if they were to let him plead to accessory after the fact and agree to say a 10-year sentence, he's only doing 3.5 years. He's walking out today, right? And he's able to then testify. So, there's all sorts of ways they can work this. And I mean, I guess they just got to decide how valuable his testimony is. Um, but yeah, so looks like we have 4 people over here in the Ole Miss case. So welcome, guys. Welcome. Say hi in chat. And everybody over here in the Coroner case, like I said, we are dual streaming right now. So I'm talking to you guys dually on both streams. But as I was saying, tomorrow we will have, for those of you who might not have been in here, tomorrow we will have 3 trials going on: the Ferris case, this case, or both of these cases, depending on the one you're listening to this from. And of course, we'll keep the links up so you guys can move between the 3 as you're going. Make sure as you're moving between the 3, make sure you hit the like button on each one, so it helps get us into the algorithm, helps build more people into the chat, introduce more people to us. That's what we want. Get more perspectives. But we'll see what happens here. So on the Ole Miss case, let's talk about that for a minute, guys. For those of you that are in the Coroner case, we're going to talk about the Ole Miss case. That is the Sheldon Timothy Harrington case. So this one is an interesting case so far. What have we seen so far in this case? We've seen 4 witnesses. And what we've really seen the state establish, because remember, this case is so unique in the sense that they don't actually have a dead body yet. So they actually have to go through the process. Even though a judge has already declared them dead, the defense actually gets to raise the issue in this case that, guess what? He can't be found guilty because there isn't a dead body. Can they prove anybody actually died? And if the state can't prove that anyone actually died, even though they might say, well, it's likely someone did, it's possible somebody did, but they have to prove beyond a reasonable doubt that this young man is dead, that he didn't run off somewhere, that he didn't do it, that he didn't take his own life. They have to prove beyond a reasonable doubt that there's no other possibility. So that's why what the state is doing right now, the first focus is showing through family, friends, the fact he didn't show up at his job, the fact that his best friend goes over and does a welfare check and his dog's left at the house, which is unusual. His car is found abandoned, which they haven't presented evidence on that, but you heard talk about it, that he doesn't let other people drive his car. That's his baby. He certainly is not going to do that. You got the mom who says, completely out of character, he always calls and sings me happy birthday. And then you have, of course, a lot of things that are being kept out from the jury right now, but you've got that gentleman that you heard testifying who says he talked to him at like 6:58, and he said he was going back over to somebody's house whom he was already at. Now, the state believes they can establish, based on that evidence, that what he was referring to and that the place he was going to was Sheldon Harrington's. Now, this is a case that is kind of reminds me of the first case my dad ever had, where there was it was a gay love triangle. And in that case, he successfully was able to argue his client innocent. But in this case, we don't even have a dead body at this point. But what we seem to have here is a young man who might have wanted to hide the fact that he was engaging in homosexual activity, and that he possibly went to some pretty terrible lengths to try to do that. And that apparently there was some sort of dispute going on, that there was a threat. Well, the state calls it a threatening message. Defense says it really wasn't. That you don't know what it was. So was it a threatening message or not? But apparently that the victim said something to the effect that if, this could go very badly for you or something like that. And then you've got basically web searches from the defendant who's searching how to strangulate somebody quickly, how to get out of the country. And then there's evidence we've yet to hear, but that was talked about in opening statements, which is going to be footage of him running from the location where this young man's car was ultimately found. There's footage of him going, getting a shovel and a wheelbarrow from his parents' house. And that's it. So the defense, rightfully so, from a legal basis, is like, hey, there's a lot of doubt in this case. There's doubt as to whether there's actually anyone died. There's doubt as to whether or not this guy did anything to anyone. There's doubt. Nobody knows where or when it happened. As the defense said, there were 71 searches and there's been no evidence found of blood or anything like that. Now, if it was a strangulation, there really wouldn't be blood. There really wouldn't be an overabundant amount of DNA. So that kind of is like, it makes a point, but it doesn't. But the reality of the situation is like, where did this college kid, hide a body so well that nobody's been able to find it? And that's going to be something that's going to weigh heavily, I think, on this jury. On top of that, it's a Mississippi jury. If you were watching the banter between judge and jury on the breaks, they're talking about their pews at church. So in my opinion, it sounds like there's some older people on this jury. I think that there's going to be a great deal of, or at least what the defense is going to hope to depend on, is some bias here to say they don't like the victim. They don't like the victim's lifestyle. So
you are here today with your client, Christopher Dontell, to enter a guilty plea for criminal conspiracy and murder, as well as accessory after the fact. Is that correct?
That's correct, Your Honor.
And have you had a chance to discuss the elements of these crimes as well as the evidence that's in possession of the state?
I have.
Have you also had a chance to discuss with him his constitutional rights and any defenses he may have if this was to proceed to trial?
I have.
I see here that he has signed an initial by acknowledgement of rights form, indicating that he understands his various constitutional and trial rights, but that he'd like to waive those and enter a guilty plea here today for those two charges. Is that your understanding, Ms. Jackson?
That is correct, Your Honor.
And do you concur with this decision?
I do.
Good morning, Mr. Dontell. How are you? Good morning. Mr. Dontell, are you currently under the influence of any drugs or alcohol or anything else that would affect your understanding of what we're doing? Are you aware of any mental, physical, or emotional problems that would prevent you from understanding these proceedings? Now, Mr. Dontell, you're here with your attorney. You have signed an initial by acknowledgement of rights form, indicating that you understand your various trial rights and constitutional rights, but that you want to waive those rights and plead guilty here today. Is that correct? Correct. And you understand that we've already picked a jury on this case. The jury's here. And if you would like a trial, we can have a trial.
Your Honor, I don't believe you're sworn.
Well, you're correct. Let's go ahead and swear in.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Mr. Dontell, now that you've been sworn, does that change any of your interest in previous questions? We're going to go over them just to be on the safe side. And again, are you under the influence of drugs or alcohol or anything else that will affect your understanding of what we're doing? Are you aware of any mental, physical, or emotional problems that would prevent you from understanding these procedures? And again, I see that you signed an initial my acknowledgement of rights form indicating that you understand your trial and constitutional rights, but you want to waive them here today and plead guilty to these two charges. Is that correct? And you understand that we picked the jury the other day and that they're here waiting if you would like to proceed with your trial. I also want you to understand that the case that we have and these charges, you obviously have a right to have your attorney here. And I'm just going to go over some of the rights that you've already signed and initials that you understand. But you understand that at your trial, if you would have gone to one, you would have had your attorney with you. You would have been able to call your own witnesses. You would be able to cross-examine any witnesses the state may have. You understand that? You also would have had the right to testify or not testify. You understand that? And I want you to understand that if you had chosen not to testify, I would have instructed the jury that they can't hold that against you. You understand that? But you'd like to waive all of those rights and plead guilty here today to criminal conspiracy to commit murder and accessory after the fact. Is that correct? And are you doing this of your own free will and accord?
Yes.
And have you had an ample opportunity to discuss these matters with your attorney? Have you also had an opportunity to see the evidence that's in possession of the state?
Yes.
And you've discussed all of this with your attorney as well as the elements of these crimes?
I have.
Thank you, sir. If you'll listen to the solicitor as she puts the facts on the record.
Thank you, Your Honor. Your Honor, if the state would proceed to trial, the evidence that will be presented would show that while Mr. Dontell was working as a deputy coroner for Orange County, he began a relationship with the co-defendant, Meagan Jackson, who was involved in body transport. As a result of that relationship, Meagan Jackson became pregnant with Mr. Dontell's child. There were anonymous messages being sent to Mr. Dontell's wife, which caused problems. Additionally, Meagan Jackson expressed to Mr. Dontell issues that she was having with the victim, Gregory Rice. She also specifically said at one point that she would cut his brake line, or this is my best chance to get rid of Greg. There were a number of occasions and text messages to support this where Mr. Dontell and Ms. Jackson would essentially engage in target practice. On the day of Mr. Rice's disappearance, there is surveillance video showing Mr. Dontell and Ms. Jackson leaving their community in separate cars. There is what the state believes to be a blow-up doll in the passenger seat of Ms. Jackson's car. And at one point in a text message, she had said, "We can go to the woods and play with blow-up Betty." It's the state's contention that that was sort of target practice. That's hours before Mr. Rice disappears. The defendants then go to Abuelo's, and then at some point, Mr. Rice is brought by Ms. Jackson to Myrtle Beach Funeral Home. His phone last connects with a network at 11:06 approximately that night, October 2nd, 2020. And that's the Lowe's Food on International Drive, right at 31. According to Mr. Dontell in his proffer, the next day, he knew that Mr. Rice had been at the funeral home. He does not know, according to him, what happened to Mr. Rice that night. Mr. Dontell has told us before that on the next day, which would have been October 3rd, 2020, that Ms. Jackson said to him, essentially, "It was him or you. I need you to go get him out of the cooler at the Myrtle Beach Funeral Home and get rid of him." We then have surveillance video of Mr. Dontell at the Lowe's home improvement store purchasing items that were later found to be used to dispose of Greg Rice's body, specifically a tarp, ratchet straps, 2 cinder blocks, and some zip ties. There was a sheet found wrapped around the victim that matched the sheets at the Myrtle Beach Funeral Home. There's also cell phone data showing Mr. Dontell pinging off the tower near where the body was dumped. And LPR, it's showing
Dontell? Mr. Dontell, you've heard the facts as stated by the state, what they believe were the facts that occurred that night, or those over those period of days. Are those facts true and accurate?
Yes.
You understand when you engage in activities like that, it's breaking the law, correct?
Correct.
Are you pleading guilty to these charges freely and voluntarily?
Yes.
Are you satisfied with your attorney?
Very much.
Has she answered all your questions?
Yes.
Do you have any questions of me?
Not.
And you understand that by pleading guilty, you're giving up your right against self-incrimination. You understand that? Because you're telling me that you committed these crimes. Other than the state allowing you to plead to these two charges, has anybody promised you, threatened you, or coerced you in any way to get you to plead guilty? This is your decision to plead guilty.
Yes.
Again, you're doing this freely and voluntarily with no coercion by anybody else.
I am.
Have you understood all of my questions?
Yes.
Have your answers been the truth?
Yes.
And you understand that the sentencing range on these penalties is 0 to 5 on the criminal conspiracy and up to 15 years on the accessory after the fact. You understand that? And that I could sentence you to those penalties consecutive. You understand that? Meaning that it could be a total of 20 years.
Yes.
All right, Mr. Dontell, I find that your plea is freely and voluntarily made with the consent of competent counsel whom you tell me you're satisfied. I will accept your plea. The state has indicated that they would like for you to hold sentencing in advance to a later date. I do want to retain jurisdiction on this case given that you have pled in front of me. Like I said, I believe that your plea is freely and voluntarily made, so I will accept it, and we will withhold sentencing or hold sentencing in advance to a later date. Thank you. Anything, Ms. Zimmercheck?
And Mayor, we appreciate you as maintaining jurisdiction. We appreciate the state working with us to make sure that the facts are correct, and we will just look forward to appearing from you. And
May we return?
Yes. All right, Mr. Dontell, let me get you to stand. The state has indicated they would like me to ask one other question of you. Mr. Dontell, you were pleading to criminal conspiracy and accessory after the fact. Were you the person who killed Gregory Rice?
Yes.
And Mr. Dontell, you understand that I'm not going to entertain any kind of bond motion prior to sentencing. You understand that? Thank you. Anything else from the state?
No, Your Honor.
Anything else from the defense?
yes,
Thank you. We'll be at ease about 10 minutes, and then I will bring in the jury and release them.
thank you.
Thank you.
So he's pleading guilty to accessory and they're using this for him, like he's pleading guilty to 2 of 4.
gentlemen, good morning. How are y'all? Did y'all enjoy your visit? Yes, sir. I heard there was a juror that was planning on making breakfast for everybody. Was that?
She cooks for us.
Well, I really appreciate your patience. Y'all have been so patient over the last few days. I told you down in the jury room the first morning that we were never going to waste your time, and that if we were not bringing you out here is because we were working, and we had been doing this. The reason we sent you home yesterday and the reason we're just now bringing you out is that the defendant in this case has decided to plead guilty. He pled guilty this morning in front of me to conspiracy to commit murder and also accessory after the fact of murder. And I can tell you with 100% certainty that y'all are the reason that he did that. And I say that because jurors, when they're brought in, often bring a realization that this is real, that the jury's here to try this case, that and it puts it all in perspective. And that's why I truly believe that we have the greatest system on earth. I truly believe that. I just want to thank you so much again for your patience. I know y'all been back in that tiny room. You probably know way more about each other than you ever thought you would. I thank you for being here. I know that the state of South Carolina, through the solicitor's office, the 15th Circuit does, and I know that the defense counsel does. We all took oaths when we got our position, and you have taken oaths as jurors, and I know y'all are here to do your duty, and I certainly appreciate it. With that being said, I'm going to excuse you with this caveat. There may be another trial this week. The solicitor's office is working on that, and we may end up pulling another jury tomorrow morning. So what I'm going to ask you to do is call in tonight. You'll receive the instructions at that point, and I may or may not see you tomorrow morning. But again, thank you so much.
Thank you.
Thank you.
Sorry. Anything else from the state?
Nothing from the state.
Anything else?
Nothing further.
Thank you.
Thank you.
And I think Mr. Hallford would just get in touch with me about.
Yes, Your Honor. My understanding is that we'll have a witnesses here this afternoon for the two pretrial motions. But if you guys need anything, just let me know.
If you can just relay to him that we'll try to, if he can have everybody here at 1:30, we'll get started.
We'll do that.
Thank you.
Thank you. Oh, and Your Honor, we want to update the roster. Christopher Williams never showed up on Monday, and so he's being subpoenaed for roll call, I think.
Okay.
Okay.
All right, thank you. And Pickett will just continue.
I believe we have already on one of the January.
All right, thank you.